Hello friends, welcome to the National and International Affairs. In this video, we are going to learn something about New Digital India Bill. Our Parliament is going to draft a Digital India Bill, and this will replace the Information Technology Act of 2000. Now, in this regard, let us know about Information Technology Act along with its loopholes. It is the primary law in India dealing with cybercrime and e-commerce, and it is based on UNCITRAL model, which is recommended by the General Assembly of United Nations. According to this act, a person of other nationality can also be detained under the law if he is trying to conduct a cybercrime in India. This act also provides a legal framework for e-governance by giving recognition to electronic records and digital signatures. And if there is any regulation issue in the digital signature, then there is a controller of certifying authority to check it whether it is correct or not. It also establishes a cyber appellate tribunal to resolve the dispute arising from this law. This act also amended various laws like Indian Penal Code, Indian Evidence Act, Bankers Booked Evidence Act and Reserve Bank of India to make them compliant with new technologies. Now coming to the loopholes of IT Act. According to the section 66A of IT Act, if someone sends offensive message through communication services like WhatsApp, Facebook, then it will be seen as a crime and accordingly he will be punished. And this section basically violates the free speech provided by the Article 19 of our Indian Constitution. For example, I know that I have the right to speech and expression according to the Article 19 with some reasonable restrictions. But the reasonable restrictions should not be upon the discussion of political leaders and making of cartoons of political leaders and sending them through the communication services. So in the Shreya Singhal versus Union of India case 2015, Supreme Court struck down this section of 66A. Now the main question is why the present regime is untenable. The current IT Act defines an intermediary to include any entity between a user and the internet. For example, Facebook, WhatsApp, Netflix, YouTube, these are some examples of intermediaries. The IT Act also classifies these intermediaries into three main categories, such as social media intermediaries, significant social media intermediaries, and the recently notified online gaming intermediaries. But the classification is not reasonable because same sets of rules cannot be applied to all sections of intermediaries. For example, I cannot make same sets of rule for Zoom app and YouTube app because the probability of dissemination of fake message is more in YouTube than the Zoom app. Zoom is a online meeting app. Its users are basically less than the users of YouTube. So different sets of rules should be made for these two applications. Now the global standard is that there is a clear classification of intermediaries according to their functions. The European Union's Digital Service Act is probably one of the most developed framework in this regard because it has a clear classification of intermediaries. Similarly, Australia has a eightfold classification in this regard. So our new digital bill should have clear classification of intermediaries and the regime should be reasonable. Along with the sets of rules should be in compliance with the interest of users and intermediaries, provided that it should not violate the freedom of speech and expression according to the Article 19 of our Indian Constitution. So this is all about the new digital bill which is going to be drafted. If you like the video, then don't forget to subscribe our channel. Thanks for watching. God bless you.